So Purcell is saying, we don't want voters to be confused by changing the rules at the last minute. And so, why are you changing the rules? Why are you why are you stopping a state that's already passed laws from enforcing the law? So then, after that case came down, Arizona has registered federal form registrants who do not supply citizenship as federal-only voters, okay? If you don't have citizenship, you just get this. You don't get to vote in Arizona elections. So go vote in the federal election. While Republicans comprise 34.5% of the total registered voter population in Arizona. So 85% of the people who get those ballots, Democrats. Battleground state of Arizona is now filing an emergency petition to the Supreme Court asking for a stay. It's going to Judge Alina Kagan. We'll see what she does with it, but it's a critical issue. It's about illegal aliens voting in the United States, in particular in Arizona, which is a very critical state for both sides to win this election season. The Arizona Republicans and the RNC are taking this directly up to SCOTUS, and there's a lot of confusion around this issue, and so I want to spend some time on this so we know how this is happening, because if the right says illegal aliens are voting, the left says it's illegal, they're not allowed to do that, and we then have to understand how the mechanics work. And this application for a stay explains how the law evolved and why this is such a problem that the Democrats are exploiting, knowingly exploiting it, so that millions of people can get some sort of a vote in past the finish line. So Senate Republicans shared this. Look, as promised, okay, the Arizona State Senate is taking its fight to protect election integrity in the U.S. to the Supreme Court. We filed an emergency application for a stay asking the Supreme Court to block an absurd ruling from the Ninth Circuit Court of Appeals that allows people who have not provided proof of citizenship to register to vote. It's going to be very nuanced here. Are they getting forms? Can they vote? Proof of citizenship? What can they do? As well as cast a ballot in federal elections and to vote by mail. So Arizona put in a bunch of limitations. Look, if you can't prove you're a citizen, you can't vote by mail. You don't even get a ballot for that type of an election, and we'll go into the details. The Republicans here say only U.S. citizens should have the privilege of voting in Arizona and in the United States. And so we'll see if the Supreme Court weighs in. But here is what it looks like. An emergency application for a stay filed by the RNC from Arizona in the Supreme Court of the United States by these amazing attorneys, Tyler Green, Gilbert Dickey, Connor Woodfin, Corey Langoffer, and others in this matter, saying the parties, as we know, are going to be the Republican National Committee, people from the Senate. The respondents are Mi Familia Vota, Voto Latino, Living United for Change in Arizona, and a bunch of these other Democratic organizations with multiple different names in there. Like, see all these are very hard. It's hard to keep track of all of them because they just shove names in there. Like, for example, the Arizona Asian American, Native Hawaiian, and Pacificer Island for Equity Coalition. It's like a full sentence, man. That's one title. Hi, this is Rob calling from the Arizona Asian American, Native Hawaiian, and Pacific Islander for Equity Coalition. Who? It's Rob from the Arizona Asian American, Native Hawaiian, and Pacific Islander for Equity Coalition. Oh, it's you. Hey, okay. It just goes on and on and on. It's like, shit, like LGBTQ plus IXB, Aladocia, Spirit People, the whole, it's like, come on. The Secretary of State and others are also responding to this. The related proceedings are as follows. So let's go through it. They are sending this up to Judge Alina Kagan. All right, look, Supreme Court. This court has repeatedly told us over and over again that this Purcell principle, this concept of let's keep things status quo, okay, the Purcell principle, let's not make any sudden movements, is this idea. Let's keep things the same. It stops federal courts from enjoining or stopping the enforcement of state election laws with an election impending. Okay, it's a complicated concept. But if a state has election laws in place and an election is coming up, the status quo principle is saying that courts cannot remove those laws. Okay, look, an election is around the corner. It's like, hey, the game is starting in like 10 minutes. You can't change the rules 10 minutes before the game starts. Otherwise, no one's going to know how to play the game. So Purcell is saying, we don't want voters to be confused by changing the rules at the last minute. And so, why are you changing the rules? Why are you why are you stopping a state that's already passed laws from enforcing the law? It says state officials want to protect their elections. But the Ninth Circuit here turned this principle against the enforcement of state election integrity laws. So Arizona passes all these things, stopping preventing illegal aliens from voting. We have an election coming up. There's rules in place. The Ninth Circuit says, no, can't do that. Hey, the status quo Purcell principle says you can't do that. It says as a general interest, there is a status quo, and that we have an interest in a status quo, including a status quo where the district court has enjoined state election law. Now, a divided panel overturned a stay unanimously granted by another panel just days before. So then there's an injunction. Okay, so a lower level court says, Arizona, you can't have your illegal alien laws. Then there's a stay on the order saying you can't do that. So in other words, you can do it. Ninth Circuit says, okay, you know what? The people who said you can't enforce the law, they're stayed. Sorry. Then another panel reverses them. What? The majority says a divided panel overturned a stay that was unanimously granted by another panel just days before. So one panel says the laws can go into effect and then they get reversed immediately. The majority revived a district court injunction. So the lower level court said that Arizona laws that require registrants to prove their citizenship using this form cannot be used. But the Purcell status quo says when a lower court intervenes and alters the election rules, the appellate court must correct that error, even if it doesn't want to do it. Like, it's the rules. You don't get to change the rules at the last minute. But as this judge noted in the dissent, when they reversed us, they abandoned regularity. It led to this peculiar result where 2 judges prevailed over 4 who had voted to stay the order. The 4 judges who voted for the partial stay, the stopping of the enforcement, the panel majority found that the Arizona registration law could not be enforced. And this is going to get wild because of a consent decree. Okay, this is just kind of an introductory letter to Judge Kagan. Then we're going to get into the meat and potatoes. So this is where it just gets even more wild. There's a consent decree. It's a private agreement between a single executive office, which in this case is going to be the Secretary of State, years before the Arizona legislature even enacted this law. Now, the Ninth Circuit also refused to stay the injunction, and this is an unprecedented abrogation of Arizona and our legislature's sovereign authority. We need relief immediately. We have to print ballots, Judge Kagan, by soon, like now. We got until August 22nd. That deadline to resolve any of this ballot stuff is August 22nd. This emergency application also concerns the form and the printing deadline of ballots, and you guys just reversed us. Like, you just changed the rules that were already in existence. The Purcell principle says status quo needs to be maintained, even if you don't like it, because the rules can't change at the last minute. They changed them at the last minute anyways. Now, it's trying to implement its prohibition on voting in presidential elections by individuals who've not provided documentary proof of citizenship. So Arizona must either not print the presidential candidates on the federal-only ballots, or it must configure its tabulation machines not to count the presidential votes on federal-only ballots. And so, accordingly, we need an immediate stay of this injunction to the extent that the courts are requiring Arizona to accept state form voter registration applications lacking proof of citizenship, right? The courts are going to force Arizona to accept these voters and to allow voters who have not provided proof of citizenship to cast ballots for president or by mail. Arizona created laws. We need to see citizenship. And if we don't have it, you don't get to vote for president and you don't get to vote by mail. All was in place until the courts reversed. Now, the court has jurisdiction over this. And here's the statement to the Supreme Court about why this stay should be granted. Background. Since 2004, Arizona has required newly registered voters to provide documentary proof of citizenship. Now, this court, Supreme Court of the United States that we're in, held that the National Voter Registration Act, a federal law under U.S. Code, preempted that requirement. Supremacy Clause of the Constitution says that the federal law supersedes and is supreme over Arizona law. So if there's a conflict, feds win. It preempted that requirement as applied to individuals using the federal form from the Elections Commission. So federal law created a form. Arizona says that your form doesn't include a checkbox for citizenship. And so we're going to add a checkbox essentially for citizenship. Then the court said, no, you can't do that, okay, because our form is the final word. But it did say that state-developed registration forms may require information that the federal form does not. So there's a National Voter Registration Act if they're using the federal form to register to vote in federal elections, okay? But the states can create their own state-developed forms. You can't change our form, but you can create your own forms. So then, after that case came down, Arizona has registered federal form registrants who do not supply citizenship as federal-only voters, okay? If you don't have citizenship, you just get this. You don't get to vote in Arizona elections. So go vote in the federal election, who are eligible to vote only in federal races, right? So Arizona changed the system a bit. State form applicants must still provide documentary proof of citizenship. citizenship. Now, continuing. So then we have these two forms, federal-only voters, federal-only races, or these two buckets, and applicants must still provide documentary proof of citizenship if they're voting in state races. So then, after 2020, when Arizona was rigged, in 2022, Arizona enacted several reforms to its voter registration laws. Two aspects of this legislation are relevant. First, this law requires election officials to reject any state form application that is not accompanied by proof of citizenship. So there's a new requirement. You're going to vote here, Arizona registration form, Arizona. If you don't have citizenship, it's gone. And second, it provides that voters who have not provided documentary proof of citizenship may not vote for president or by mail. So you don't get mail-in ballots. We're not giving you all of that stuff. If you want to get a mail-in ballot, show us you're a citizen. We're happy to pay for the postage to get it out to you. Now, the United States, the government, and various private plaintiffs, the ones, the Latinx organization, the Asian American, whatever, Jamaican, whatever, all the things, all join in. They initiated litigation. They say, whoa, proof of citizenship, that's terrible. That's not what we're even in existence for. Now, because the Secretary of State refused to implement the relevant provisions of the law in 2022 because they're a Democrat, the plaintiffs never sought or obtained preliminary injunctive relief, right? So they're like, well, it's not being enforced, so we don't need to sue. So then the district court ruled on partial summary judgment motions in September 23. The district court said that the federal law preempted the provisions relating to presidential electors and mail-in voting. So the federal law beats the state law, and that Arizona must continue processing non-compliant state form registrations in accordance with the LULAC consent decree. Now, this LULAC consent decree we're going to talk more about. It's this private contract, basically, between an executive branch and another entity. Now, the RNC then, right, so in other words, process the illegal votes, voter registrations. You don't need proof of citizenship. So then the RNC moved for a partial final judgment on those issues in early October, but the district court did not enter an appealable injunction until May 2nd, 2024. So then the applicants here sought an emergency stay of the injunction, right? So now there's a law that says that they can reject the ballots, and now they're being told, stop rejecting the ballots. Let in the no proof of citizenship stuff, and it's not necessarily the ballots. I keep saying that, but we're talking about registrations right now, which will ultimately lead to ballots, which is why I say that. So allow them now to continue to process those so that all of those ballots will go out all over the place. Stop it, right? You guys have to keep processing those. So on July 18th, a motions panel unanimously stayed the injunction to the extent that it prohibited the enforcement of that law. So they said, well, no, actually, the district court telling them to stop the processing, you stop. And Arizona, you can stop processing the registrations that don't have proof of citizenship. So then several plaintiffs sought reconsideration, right? Then they went back up to the Court of Appeals that just told them Arizona law is fine. Their motion did not raise any new arguments. It repeated the same argument that this LULAC consent decree barred Arizona. So this like private contract that was entered into stops Arizona from being able to even check for citizenship for state form registrants. And to support their reconsideration motion, they pointed out that the Maricopa Recorder had begun enforcing the documentary proof of citizenship requirement for state form registrants. They argued that this enforcement caused confusion and that this violated the Purcell principle. So they're saying, no, your change caused the confusion. So then the Ninth Circuit, they had an emergency briefing order. A divided merits panel lifted the partial stay over the judge's dissent. It found that the LULAC consent decree requires county recorders in various counties to accept state form applications without proof of citizenship, despite Arizona's new law. So the Arizona legislature passed a new law, but the LULAC, this is a consent decree. So it's between, let's say, the Secretary of State, I think they'll give us some facts on it, between the Secretary of State and some private organization. So the legislature has their power to pass legislation that governs the elections stripped from them because the Secretary of State entered into some other transaction with somebody else. They contracted away the legislative power, and it found that the original stay panel had caused a manifest injustice by failing to apply the Purcell principle to continue to enjoin enforcement of Arizona's law. So then Judge Bumate first noted that, this is unusual for a motion for reconsideration. How can you reconsiderate with no facts or law? Saying that 2 judges prevailed over 4 because of the luck of an internal Ninth Circuit draw, right? They just tried again, got a better draw. He explained that allowing a consent decree between a private entity to prevail over later statutory enactments, right? So it raises serious separation of powers concerns. He says, no, consent decrees must yield to statutory changes. The legislature has more power than a Secretary of State state entering into some agreement that binds the rest of the state in perpetuity. He also noted that Purcell was not a tool to upholding injunctions barring the enforcement of state law. So you can't do any of that. Now, litigation affecting what will be printed on Arizona ballots must be resolved within a matter of weeks. So Supreme Court, we need you to hear this. Now, in order to grant stay, this court will do that if there is a reasonable probability. So in other words, stay the stopping of Arizona rejecting the registrations and the ballot. We need 4 justices. If we think that they'll consider this and grant cert, that's enough. Saying that if there's a prospect that the majority of the court will reverse below, you need to accept this. And if there's a likelihood of irreparable harm or injury that will result if you don't grant a stay, it leads to us believing you should accept a review of this case. Saying there's a high probability here that this court would grant review, and there's a fair prospect that they would reverse this. Why? This court's prior orders granting stays of injunctions that change state election laws only confirm that the Ninth Circuit's actions need intervention here. They're giving us examples of other cases where 27 days before election, 36 days before election, 61 days before an election, this court would intervene. We know we're doing the same thing here, trying to avoid voter confusion on the eve of an election. The Ninth Circuit turned this shield for state laws into a sword to impose judicially mandated status quo, and this court is likely to review this. The Ninth Circuit actually displaced election rules that were enacted by the legislature, and they did that based on its erroneous conclusion that an executive branch official, like the Secretary of State, can bargain away to private litigants and the legislative branch and their constitutional authority to regulate elections. In 2018, then Secretary of State executed the LULAC consent decree, which provided that if an applicant submits a state form without a documentary proof of citizenship, she will be registered as a full ballot voter if her citizenship can be confirmed using information on a file with the Arizona Department of Transportation. If her citizenship cannot be verified, she will be registered as only a federal voter. Okay, so this person, they get a full Arizona ballot with the federal races and the Arizona races if they are citizens of Arizona. It was Katie Hobbs, Secretary of State, who's now our governor, was creating this deal. So Katie Hobbs enters into this deal with this LULAC, and then they agree this is how we're going to do it indefinitely. And now the courts are saying that we're bound by that decree. Now, if the person's citizenship cannot be verified, they still get a federal-only voter. So they still get to vote in the federal elections. So there is no proof of citizenship. They still get a ballot. The ballot will still count. In 2022, the Arizona legislature exercised its authority under the Constitution and instead mandates that state forms lacking documentary proof of citizenship must be rejected, okay? You don't get a federal-only ballot. You don't get anything. We don't process it because you're not a citizen. The Ninth Circuit holding that the LULAC consent decree overrides the Arizona legislature is a serious separation of powers concern. It would mean that a judgment entered unilaterally by some executive branch officer like Katie Hobbs indefinitely displaced the legislature's power. In other words, the executive branch can circumvent the Congress. Such a judicially imposed distortion. This happened all over the place, by the way, in 2020, all over the place. And they used COVID to do it. The state's chosen allocation of sovereign authority would now bind everybody. And in cases where different state actors have different views, it would present serious practical risks. An executive officer would be sorely tempted to dictate new terms by entering into a contract. The invocation of the consent decree to displace the Arizona legislature is serious, especially on issues of election administration. The Constitution, both the federal and the Arizona Constitution, says the state legislatures govern the elections, not Katie Hobbs and her contracts, saying the Supreme Court is likely to reverse this court the displacement of Arizona. There's a lot of precedent for this. When a legislative body changes the law, you abide by that. Now, the majority's protestation that a legislature cannot nullify a judgment entered in by an Article 3 court, they're saying a consent decree is much different than that. If the Arizona legislature had rescinded voter registrations, it could have evoked constitutional concerns, but they didn't rescind anything. It's for new registrations coming down the line. Now, this case presents also 2 additional important election integrity issues. A state has a compelling interest in making sure we have qualified elections, and allowing an unqualified person to register and vote, it harms the right to the actual voters. It debases our votes. It dilutes our votes. It undermines our confidence in the electoral process. And so for this reason, this court has heard other cases about this before. There are similarly important issues here. Arizona law permits only those applicants who can provide documentary proof of citizenship to vote by mail. This restriction protects Arizona elections by giving mail-in voting where the fraud risk is real only to qualified citizens. The district court found that this also violated the federal rules. Even though the statute addresses procedures to register to vote in elections, there is a reasonable probability that this is about voter registration, not about voting. There was also more than fair prospect that the Supreme Court would reverse here. To begin with, the district court applied the NVRA, a law governing voter registration, to prohibit Arizona's requirement of documentary proof for citizenship in order to vote by mail. Neither the district court nor any party has reconciled this preemption of state mail voting rules by a statute that addresses the registration to vote process. They're just saying it's consistent with the purpose of increasing registered voters. So they haven't been specific enough about how that mail-in provision has been superseded. Now, the district court also read the NVRA to reach state rules about presidential electors. The district court ignored those textual limits because it thought that this court's decisions had expanded Congress's power. This court has given Congress the power to display state rules for registering and voting in presidential elections. That case merely confirmed something about the Federal Corrupt Practices Act. And if you don't grant a stay here, Supreme Court, there will be irreparable harm. The Ninth Circuit sidestepped the sovereign interest of Arizona by saying that even the Attorney General posed a stay. Great, Chris Mays, who cares? But another Democrat who doesn't want a stay. But the legislature has the authority, not all of these executive branch officials. The injunction harms the Arizona legislature as an institution that has the sole authority. They dictate the rules of the mail-in voting option. And the Secretary of State's promises in the LULAC consent decree cannot override the democratically enacted laws. It undermines the Arizona legislature and the people who are represented by them. It's also going to harm the RNC. We don't want changes in the 11th hour as an election is right around the corner. Here's some interesting numbers. According to the plaintiff's own expert, only 14.3% of federal-only voters are registered as members of the Republican Party. Look at that. While Republicans comprise 34.5% of the total registered voter population in Arizona. So 85% of the people who get those ballots, Democrats or something like that. And because elections like admissions are zero-sum, they come at the expense of the other votes. The district court's order requires including individuals who have failed to satisfy the minimum state law requirements to be able to get a ballot. And so it would also harm the public interest. There's no evidence that proving that you're a citizenship is going to impede any qualified voter from registering to vote. I don't know what's so hard about proving you're a citizen to vote. Worse yet, the panel compounds the errors and they disregard an absolutely valid state statute. So they say that this court should issue a requested stay before August 22nd, 2024, respectfully submitted here in the United States Supreme Court from the RNC battling back all of those entities. So I think it's pretty clear on its face what it looks like. We see they don't want anybody to have to go through proving their citizenship because they'll get a valid federal ballot anyways. Just don't say it and they'll just get it. If you can't prove it, great, you'll get a federal only anyways. Amazing. And they'll be able to cast those ballots and vote. And 85% of them are not Republicans. So you can see why they fight so hard. And again, this is the same thing that happened in 2020. Okay, they're usurping the power from the legislature. The legislature tried to fix what happened in 2020. The courts are stealing it away from them again. And this was another big steal. Okay, the Ninth Circuit originally came back down and said, no, that's the law. You're allowed to do that. Then they requested a review. A new panel came about and reversed it. That's in Arizona. So in Arizona, we will have a ton of illegal aliens, unless this changes or unless the Supreme Court comes back out and reverses this, registering and getting ballots. That's how it's going to work. The consent decree at this moment, according to the Ninth Circuit, is overriding the state laws so that they can steal the state of Arizona again.